order, but it has to do with,
We're not changing the parameters. If you submitted an order, she submitted a Rule 11, we're going to go based on that, and we just need to make decisions. So let's, Mr. Pettit, Ms. Pettit, I'm sorry, if you could go ahead and share a screen on the two orders.
Can you see, I'm just going to go through Mr. Scott's order because I think that's easier. I've got some red lines in here
Okay.
where I think we'll need some rulings from Your Honor. So this is his proposed order. Any changes to it are either in red or have my yellow highlighting. So the first part is just regarding the date for amended pleadings. I think both Mr. Scott and myself have both filed it, so I don't really know that we can put today's date in here, but I don't think there's anything else that we need to do on this particular paragraph now that we've both filed, unless Mr. Scott.
I'm sorry, Tony, we are on the record.
So I think April 19th being today should take care of paragraph 1 now that Mr. Scott and myself have filed amended pleadings. The only thing I'll note is that to the extent the court granted leave during the prior hearing, we thought on our end we still needed to file a motion for leave. If the court's saying that's not the case, then I guess Mr. Scott's suggestion here that the parties are granted leave is okay, but I just wanted to run that by Your Honor.
So, Your Honor, I'm happy to report that counsel is correct that with regard to item 1, this now reflects the current status, which is that
sounds good.
The pleadings have been filed.
Sounds good.
Going on to number 2 of his proposal, his trial amendment obviously incorporates everything that has been in their pleading. So I only think discovery should be limited to the new matters, which is why I've inserted that word new.
I agree.
During the last hearing, we talked pretty extensively about the time period for that would be relevant. The offer made by my clients that were accepted by Mr. Scott's client was made on January 5th. And so during the last hearing, we had indicated, or we discussed a limit. It wasn't a ruling from Your Honor, but we discussed a limit of January 5th to current. And so I don't think that either party should be going back in discovery on issues that have come and gone. This is about, did my clients breach a settlement agreement? Did his clients breach a settlement agreement? Go do discovery on that issue.
So, Your Honor, with regard to that, I agree to a certain extent, but the issue that we have is, for example, looking at their pleading that was filed on April 17th is a change in position, which is so on April 5th, they indicated to the court that anything related to the 2018 case, the court had no plenary power and everything related to that was up on appeal. But now we have a defense at the end of their counterclaims in which they asked for an offset on damages based upon the legal fees that they incurred in prosecuting the promissory note case from 2018. And
wait, is this a new pleading that Ms. Pettit?
This is our trial amendment.
This is their trial amendment, Judge. So while we understand that this trial is going to focus on these issues related to the house and related to the settlement and related to performance, and we've sued for specific performance, and we also say that their settlement offer was deceptive, and we'll get into all that, and that furthermore we're claiming attorney's fees based upon misrepresentations or misconduct during the original, during the trial, which we didn't waive. Now, I don't need any discovery on the misconduct related to the trial. We have everything, so there's no issue on that. But I don't want a limitation in this order that then becomes the basis of an argument at the trial. Well, Mr. Scott agreed that the only thing that's relevant in this case is from January 5th to current, and therefore...
That's not what this says. It just says that you shall receive expedited discovery on it. So I'm going to allow this on, I think this makes sense on number 2. I am concerned about this. If it's a new, did you plead this, Ms. Pettit, since the trial ended or the beginning of the trial ended? Was this a new pleading?
Both parties have filed trial amendments.
But this offset, is that something that when did you plead that?
If your honor will allow, I need to pull up what we filed and defer to Mr. Urtiago on that. I don't believe there's anything new in regard to offset, but I'm going to pull that up, and Mr. Urtiago may remember offhand.
Your Honor, I think what Mr. Scott is referring to is that there's an explicit pleading of offset in the trial amendment simply because we're claiming to the extent that we prevail on the breach of contract issue, there's potentially some attorney's fees for that. And we're just simply asking for an offset if we win on that, and we're entitled to some amount as an offset versus the damages Your Honor may give to the Zatoons on the breach of contract claim under the underlying action, for example. So it was just sort of a defensive pleading, assuming that we lost, but won on the sub-issue.
If I recall correctly, that case was severed from this case, correct?
Yes. What Mr. Scott is referring to, of course, is the severed action. However,
and that's on appeal.
That is correct. However, when we filed the original version of the pleading, not the trial amendment, but the original version, it still had those claims because of the timing of the filing and because we didn't want the Court of Appeals to say that we non-suited any of those claims. So those claims—
I just want to make clear, I don't expect there to be any discussion of this during— I'm not going to allow any discovery on that issue, and I'm not going to allow that to come into trial unless the Court of Appeals rules before the special setting.
Your Honor, and that was our understanding as well when we pled it. We by no means intended to ever argue that we should get attorney's fees on the severed action and that should offset anything without the Court of Appeals somehow authorizing that.
Okay, that makes sense.
Your Honor.
All right, next one. Any
Yes,
third
Your
party
Honor.
discovery?
The next paragraph I've inserted—
No. Let's move on to the next one.
Yes, Your Honor. The next paragraph I've inserted is just been a common issue we've experienced with Mr. Scott in the prior case and in this one. It shouldn't be controversial. If they serve third-party discovery, they need to send it to us the same day. I won't go into details, but it's a huge issue.
Isn't that already in the rules? I mean,
that is, but it unfortunately is blatantly violated time and time again. So it's just really important to us. They can't be serving third-party discovery on our banks and not giving us notice. It's just unacceptable. And I ask that this be included and enforced.
Okay, I don't know if it's necessary, but we can include it. All right, what's the next thing?
Okay, next issue is party depositions. I think Mr. Scott wanted them to be all done on the week of May 5th. May 5th is a Wednesday, so that doesn't make sense to me. I'm just saying they should be done on or before May 10th.
May 10th is a Friday?
It is the following Monday. So we're saying it would be on or before that Monday, May 10th.
Judge, can we just go back to number 4?
No, we're finished ruling. I've ruled on that. So let's move on. So do you want to talk about number 4?
Well, I was just going to say, Your Honor, that I could anticipate, since it doesn't have an end date for the service of demands for discovery, that a party could wait until the day before the trial and then wind up saying, well, now we can't try the case because it's 2 more weeks until the request needs to be responded to. I mean, I think we understand that shouldn't happen.
I'll deal with that at trial. That's not, if either side tries to do that, that's not going to work. We have a special setting. The special setting's going to go.
Okay, so are we good on number 5?
Number 5 is good.
Okay, on number 6, we have a dispute. During the last hearing, Your Honor inquired about experts. I'm going to briefly switch to a different screen if Your Honor can indulge me just 1 second. We talked briefly about experts, and here we are. I indicated when we talked about experts that it's highlighted on the screen that I wanted to confer with my client before I said whether we would or would not have an expert. Mr. Scott has taken the position that even though the court raised this issue, that I am not entitled to have an expert on valuation. I've asked him, we've got an appraiser that can come out any day this week. I've asked him for access to the property, but it's his position that I have somehow waived my right, even though we talked about it during the last hearing, to have an expert on valuation.
So, Your Honor, if I can respond, counsel, I have a different view of things. And so we received yesterday from your court reporter a rough draft of the transcript. And I'd like to share a screen so Your Honor can see what was said at the time.
I have it
My,
right here.
Let Mr. Scott share screen.
if I can just, hold on, bear with me 1 second, Judge.
All right, let Ms. Pettit share screen. Okay.
I got it, Judge.
Okay.
So this is where the issue about whether or not they would call a witness on valuation. And since we filed our amendment, we'll deal with this issue later about whether it even matters. But you see here, Ms. Pettit says, my inclination is we probably rely on Mr. Scott's expert.
Inclination, and the prior page says I need to confer with my client.
So, Your Honor, again, our biggest concern is about timing and delay. And so if counsel wants to designate an expert, for example, which has not been done yet, designate an expert, we will make the house available tomorrow to be inspected. But it's critical that the expert be required to do a report so that we can get up to speed faster. And then we need a prompt date in order to be able to take that expert's deposition if we find it appropriate.
I don't think that's unreasonable, Ms.
That all
Pettit.
seems reasonable to me.
All right, so let's get a date. When is the expert designation deadline and when is the report deadline?
I know the expert can see the property anytime this week. So if tomorrow works, then I would say that if we can have 7 days after the date he views the property to get the written report in. And then same thing, his deposition would need to be done prior to, just like the date that we had earlier in the scheduling order. I think we said May 10th.
And Mr. Scott, you said the property was available tomorrow. Is that what you said?
Yes, Your Honor. I'll make arrangements with Ms. Pettit. We can do it tomorrow at 11 o'clock.
So in the order, I wanted the inspection will take place tomorrow. The expert designation will take place for both sides the day after that. And then reports will be due 10 days after that.
Your Honor, as far as us making a designation or making a responsive report, this is not part of our affirmative case. So we're not going to be offering any testimony. We don't have a breach of contract market value damages case that we're pursuing. So we're talking about counsel wants to, this is her expert that she wants to offer on her.
I'm not requiring anybody to have an expert. I'm just giving deadlines.
And what about, Your Honor, can we set the date for the deposition? Or an outside time frame within 7 days after the reports are submitted?
Ms. Pettit?
I think the deadline for all depositions in here already says May 10th. I mean, I don't know what the expert's availability is. It will make him or her available before May 10th. Just
I think that's reasonable.
Okay, may I share screen to make sure this language is acceptable with the court?
Oh, sure.
Okay.
I think you may need to stop sharing. Let me see.
Oh, I'm sorry, Judge.
It shows that I'm screen sharing. Do you see it?
There it is. Okay, yeah.
Okay. So it now says defendant's inspection / appraisal will take place on April 20th, 2021, and expert.
We need to add an expert designation deadline.
Yeah, and an expert, I'll say designation and report.
I had said the designation would take place the day after the inspection, and then the report would be 10 days after that.
Oh, okay. Expert designation shall.
I would say expert designations in case he has a designation.
Okay.
I don't mean to be picky, but
No, I appreciate it.
Appreciate that, Judge. And Your Honor, I believe you said 7 days, not 10 days on the, okay. So Julie, you'll delete the last sentence? And then deposition
Oh, yes.
by May 10th, on or before May 10th?
actually, You're making it harder on yourself because I said 7 days from the designation, but you can say with.
I actually, Judge, that's what I prefer.
I guess I did not understand. So
Any expert
designations.
report will be due within 7 days of the designations.
Ah, gotcha. Okay.
Thank you, Your Honor.
Okay.
And I believe that is it. The only other thing, I'm agreeable, Mr. Scott, with everything else that's in here. But the only other thing I'd like to address is that Mr. Scott and I had submitted competing orders on the release of the money from the court registry that we discussed.
I already signed one of the orders. I don't
Yes,
remember.
yes, Your Honor. The issue on that I just would like to clarify for the record is that during the hearing, the court was clear, and if you can allow me just 1 second.
Your Honor, this is not in front of the court today.
It is though.
Your Honor already ruled, and you've said that we're only dealing with the scheduling order.
May I proceed, Your Honor? Just very
Make it brief.
Yes, Your Honor. The court was clear, and we were clear in our offer that that was to be offset against any amounts that the court later might find against my client. Mr. Scott was refusing to put that language in the order. Your Honor is the one.
Did it not say that in the order? I don't remember.
He's not saying that we have the right to offset that amount against amounts that may be awarded, and that was clear from both the court's perspective on page 26.
Right.
Yeah, Judge.
No, I agree with that. Can you share screen the order that I signed?
Yes, Your Honor, 1 moment.
The order said that these claims are all reserved, Your Honor, to trial. And the reason, Judge, what we're trying to avoid here is a situation of having doing something that prejudges or rules on the merits, because one of the issues that they've raised in their new petition is they claim that there's an election of remedies or acquiescence or acceptance.
Okay. I don't see how that affects the offset defense. So let's go ahead and prepare an amended order that includes that the $12,500 shall be an offset against the any eventual judgment in this case or something like that.
I will do that, Your Honor, and submit it. I think with that, that's everything. I can upload this. I'll accept all the changes in this and then upload this proposed order that we just did during this hearing.
And then you'll do an amended order for this thing here?
Yes, sir.
Okay. All righty, guys. Good seeing you, and you guys be safe, okay?
Judge,
Thank you.
Thank you.
Judge, can I just say one thing?
Ms. Hertz, do you still need a hearing? Ms. Hertz, you're muted.
I do, Your Honor.
Do you want to, Mr. Scott, I've got to get to Ms. Hurst. So thank you so much, and we'll see you on the next one, okay?
Thank you, Your Honor.
Thank you. All right, Ms. Hertz, and your opposing counsel is Mr. Jones, if I recall correctly. Is that right?
That's right.
That's correct.